So can you record it as well?
Yeah, we record. We record all of them, don't we?
Oh, good. Okay.
Yeah, we're good now. No, it's good that they changed the settings on Zoom. Before they used to have it automatically record. You would have to turn it off. Now it's the opposite. So good. Thanks for.
And you'll notify all of us of the recording?
I will send it to everybody. Yes.
Thank you.
Not Gordon, I can hear.
Yes.
Thank you, Stephen.
He's not muted. You can never mute Gordon. It's a law of nature, like physics.
I need that reputation.
Okay, why don't we get started?
I know, but you know what? I agree with you. At this stage,
Yeah.
All right.
I think at this stage we concentrate. I agree with you. I'll find that. But at this stage we concentrate on,
Who's talking? Okay.
All right. No. Okay. All right. I think we want to get started. Okay. All right. Welcome, everybody. Thank you for joining us today. For those of you who don't know, my name is Alyssa Gresh, and I'm the Executive Director of the AAJLJ. Just a couple of housekeeping notes. If you could remain muted for the presentation, that would be great. And I'm sure you all know that by now if you've had plenty of Zooms. And at the end of we have 3 speakers. So at the end of the presentation, we will open it up for questions. So if you want to just type any of your questions in the chat box, and I'll kind of moderate, but you can discuss and take yourselves off mute if you want to engage with one of the speakers. So thank you everybody for joining, and I'm going to turn it over to our president, Steve Greenwald.
Hello, everyone. Thank you so much for joining this discussion today. On behalf of the AAJLJ, I welcome you, and also our partners, Padoosh and J-Plan, who are co-sponsoring this session. And we look forward to an exchange, as you just heard. If you have questions, as Alyssa said, just shoot them to us. Quickly, I just want to say a word about the background, if you will, to what discussion we're going to have. Last year, in June of June 2019, about 6 or 7 board members of the AAJLJ made a trip to Israel. We were there for about a week, and over the period of that week, we met with about 20 different individuals, all involving issues around the legal system in Israel, and issues such as the nation-state law, which I will talk about later in this program, which had then been enacted and had created some concerns in American circles and also in Israeli circles. And our focus was also on challenges to the Supreme Court of Israel that had begun to emerge or had accelerated from where we sat in our point of view. We wanted to find out more about that. There was also the ongoing and persistent issue of conflict between the religious and secular courts and law and so forth. So we had a number of issues we felt that they were worth discussions with the folks in Israel who knew something about these issues, because they were issues that were also of concern to American Jews, particularly something, for example, like the nation-state law, which had attracted a lot of interest and a lot of negative comments in the American press and in discussions among American Jews. So that was the background for our trip. As we met, as I said, with about 20 individuals, including 4 former members of the Israeli Supreme Court. Our first meetings was at Aaron Barak. We also met with Salim Gibran, Itzhak Zamir, and Eliakim Rubinstein. And beyond that, we met with numbers of other legal scholars, judges, members of the Knesset, and so forth. So Coming back from that trip, we decided that we would put together a small group, myself and Harold and Stan, and we would have a series of meetings or discussions with groups that were interested to report on what we had learned from our trip to Israel. And we actually held several of those programs and get-togethers, one in Springfield, Massachusetts, one in New York, one in Washington, D.C., and we had plans to sort of take our program on the road, if you will, to other parts of the country, Florida, New Jersey, and so forth. And then, of course, we were hit by the coronavirus. So that brought a screeching halt, not to most of our lives, but also to this program and the idea of expanding our audiences. But the good news is that we, with the thanks to technology, we, like many other organizations, have been using Zoom and Zoom-related technologies to run numbers of programs over the last several months, many with Bidoosh and J-Plan on a whole rainbow of issues related to the law, related to Israel, related to Jewish matters, and so forth. So we decided that the next step for us with our trio of speakers was to use the new technology to talk about what we learned when we were in Israel last year, which are continuing and ongoing issues. And here we are. So that's my background again on the basis for this program and the roots of the program. And with that, I'm going to turn it over to Harold Halpern, one of our board members and the first speaker today. And Harold will be talking about numbers of issues related to annexation, politics in Israel, and Harold is also a regularly published writer for his local newspaper in Sarasota, Florida, and we have posted many, many of his articles. If you go to our website, you'll read them. So Harold, you have the floor. Thank you.
All right, Alyssa, what is going on with the slides?
I'm doing it right now. Here we go.
Okay, I don't need them on right now.
Okay. I'll wait.
Turn off the slide, please.
Okay.
All right. So Steve alluded to we were going to do our traveling until the virus came, but I still want you to fasten your seatbelts because I have a lot to cover this morning on annexation, the peace plan, the UAE agreement, the government. So I have to talk rather quickly and you'll have to listen rather quickly. And I'm very pleased that all of you are here to listen to this and join in with this program and participate hopefully during the question period. Let me begin with a little bit of a story. Our first session with Judge Barak was on a Sunday. So we had, and we were then busy all week, all day with a meeting with the 20 or so people. So on Shabbat, Susan and I went to visit friends in a retirement village north of Tel Aviv. Very bright and sharp people, and after catching up with each other's lives, we of course got into a discussion of politics. At that time, an election was pending, the first of 3 elections that Israel had before it could form a government. And so Barbara said to me, Harold, you know, the Judea, Samaria, the West Bank is essential to the security of Israel. The Palestinian Authority has not accepted our right to be present in the Middle East. It's not a question about territories, it's a question about our right to exist. And so, unfortunately, we have to employ all security measures and maintain control of security over the West Bank. But there's no way I can vote for Netanyahu. He just, as a human being, he's contrary to my ethical values. And so I won't be voting for him. But she told me of the importance of the sense of security for Israelis and the need for control of the West Bank at this time, hoping for sometime in the future a change. So it was a delightful day. And then the next day we met with Aaron Barak. Now he is one of the greatest of the Supreme Court justices of Israel. He served as its president, the equivalent to our chief judge, I think for a period of about 12 years, and on the court for 20 years. He's the one who developed a great deal of the philosophy of the court, like a founding member. He wasn't a founding member, but he created the rights. Israel has no constitution, but Israel has something called basic laws. They're essential laws for the well-being of its citizens. A basic law of human dignity, for example. Well, Judge Barak in a case said, if any law passed by the Knesset or any administrative act adopted by the Knesset violates a basic law, that's equivalent to our Constitution, and we have the right to declare it unconstitutional and invalid. And that was a very important principle. It's a very, he established a very liberal principles of taking jurisdiction in many cases, which in the United States would be deemed political issues. When the separation fence or wall between Israel and the Palestinian Authority was erected, they took on a case and declared a certain portion of the wall unreasonable, unnecessary. Their standard of review is very liberal. Is the law reasonable? Is there a lesser way, less intrusive way of establishing what they're trying to accomplish? So a very liberal court. So he discoursed at length. Steve will talk to you, Stan will talk to you about some of the subjects. And I, thinking that we were at a conference that dealt with legal issues, quickly learned that you cannot separate legal from political. So I asked Judge Barak, tell me, annexation is under serious discussion by the Prime Minister. And we had all read about the claims that it was in violation of international law, that it was disputed, etc. And while he was very open to all kinds of questions, very gentle, when he heard my question, he went like this. He raised his shoulders and he said, Israel has the power to do it. There was no discussion, no willingness, apparently, on his part to discuss that issue. And I've been puzzled. I never asked him why that was. A call here in the United States, a deferral to the legislative body, a political issue that the court should not intervene with. Although in Israel, that principle generally does not exist. But it was clear that that was not something that he was going to discuss on the merits. And so he shrugged his shoulders. Then we met with many others. And I'm talking to you about my limited issue for today. We then, among others, we met with Nachum Barnea, who was probably the principal political writer in Israel for Yediot. And now, Alyssa, if you could put up the number 1, which is a map. Okay, this is it's hard to see the coloration in it, but this is a map from the Oslo Agreement. The Oslo Agreement established 3 areas in the West Bank, areas A, B, and C. Area A and B were Palestinian cities Palestinian towns, Palestinian villages. And where the Palestinians had complete control of day-to-day life, and Israel maintained the control of security in Area B. The area that's shown as white, if you can see the white on there, that's Area C. That was in total control of Israel. And that is the area, and you see the little areas nearest to Jerusalem. Those are the areas also in white, which, although part of the West Bank, are under Israeli control. So when I asked Nachum about peace agreement, about annexation, he said, Harold, there is in your lifetime, in my lifetime, probably in our children's lifetime, in my opinion, no opportunity for a peace with the Palestinians. They were offered in negotiations, 1999, 2000, that time frame, 97%, the equivalent of 97% of the West Bank. It was a little less of the West Bank, but then some portions of Israel were going to compensate for a few percent. They turned down 97% with access with the capital and the outskirts of Jerusalem, access to the Temple Mount, and they turned it down. And the analysis is it was turned down because the Palestinian Authority, well, saying it wants two states, in fact, wants a one-state solution to eliminate the state of Israel. They view us Jews as crusaders, as invaders, not belonging in the Mideast, and they were unable to accept a 97% offer because, according to analysis, they wanted anyone who had lived, was born in, or lived in pre-state Israel to have the right of return, that would, and their descendants, which would have meant millions, and which would have meant, in effect, Israel would no longer be a Jewish state. So he said that it's not going to be an agreement during our lifetime. And so how about the proposed annexation? He said, we don't need an annexation because if you look at our control, we are already controlling Area C. We have security rights in Area B, and we assert them in Area A when necessary. And we have control of the Jordan Valley, abutting which is Jordan, to protect the border there. We don't need to have an annexation. And then we met with, you can take that down now, Alyssa. We then met with members of various think tanks, liberal think tanks, conservative think tanks, and the major sense that we got from a consensus of the think tanks as an annexation now is somewhat different than the first two I told you. There it is. Annexation should not take place. It will eliminate the ability for a two-state solution. It will arouse, it will interfere with our existing peace agreements with Egypt and Jordan. It's not a good idea. And then on our last day, as at our last day, we met with Professor Kantorovich. He's a professor now at University Law School in Washington. It's called the Scalia Law School. So it happens my daughter is a part-time teacher there as well. But he's a so-called legal expert on the question of the lawfulness. What is the legal status of the West Bank? and he takes the position, I can't go into it because it's very lengthy, that the entire West Bank, Israel is sovereign over the entire West Bank. The last entity that had sovereignty over the West Bank was the Ottoman Empire. The Ottoman Empire chose the wrong sides in World War I, and its empire was broken up, and that was the end of its control over the Mideast. So it was the last entity that had sovereignty. And then through the Balfour Declaration, Act of the United States Congress, Act of the British Parliament, Act of the League of Nations, and Act of United Nations, all affirming the Balfour Declaration, which was not limited, but consisted of everything of historical Israel. So he takes the position, and others join in, that sovereignty over the West Bank is within Israel. But I don't think, from my perspective, that answers very much, because there is the practical issue that we have two peoples, the Palestinians and the Israelis, two peoples claiming one state. Somehow there are two peoples who cannot live together and must live apart in their own separate nations. Israel wants to remain both a Jewish state and a democracy, and that only can be achieved ultimately by a solution of two states. But at that time, and the Palestinians were unwilling to accept the requirements of recognize Israel as a lawful nation in the Mideast. And so they could never negotiate agreement, no matter how satisfactory it was. Now, after we left Israel, there were elections were held, and there was a deadlock. In Israel, there are 120 seats of the Knesset. You have to form a coalition of parties to get to 61, and no one could get to 61. So there was a third election that was held, and the third election was held on March 2nd of this year. And from September to March, the campaign took place. Well, in January of 2020, President Trump disclosed his peace plan with a map. And now, Alyssa, if you could put that up.
You hear? Harold?
Yes, I can hear. Yeah, I was waiting for the map of the peace plan. That's exhibit. That's slide 2, Alyssa. Well, you will see on the in the peace plan, under the Oslo map, which you saw, that's 60% of the West Bank. So the area C, which is really what's in contention, is 60%. Areas A and B, which are under Palestinian control, is 40%. So under the peace plan, 30% more is proposed to go to the Palestinians under certain conditions. That means ultimately, if there were a Palestinian state, it would be 70% of the West Bank, and 30% of the West Bank would be a part of Israel. Now, the parts of the 30% is made up of all of the cities, Israeli cities in the West Bank close to the border, not the border, close to the armistice line, the green line. Alyssa, can you show that one? That's going back to number one, or is it lost? Can't do it? Okay. So it was always anticipated in negotiations that everyone would agree, that the Palestinians would agree, that the large settlement blocks, which are near we'll call it just for discussion's sake, it's not a border, but near the border, would become part of Israel, but that Israel would abandon the smaller settlements. Well, the peace plan now, this is 20 years later, the Palestinians have refused to negotiate. They are holding Arab countries hostage because they have agreed that they will not enter into a regular normalization agreement with Israel until they settle the Palestinian problem. This really made the issue hot in Israel. The annexation, and a government finally was formed. It's a government of rivals. Netanyahu couldn't get to 60. He could only get, I think, to 58. And that would leave 62. But Gantz, the leader of the Blue-White Party, he couldn't get, even though there were 62, he couldn't get to 60 because several members of his coalition would not sit in a government with Netanyahu. So they again were without a government until Gantz said, I will go back on all my promises that I wouldn't sit with someone under indictment. And so I will sit in the government to give it a majority. But first time in the history of Israel, they made a coalition agreement creating veto authority. Both Netanyahu and Gantz have veto authority over the policies of the other, with one exception. The one exception was annexation. And Gantz agreed that Netanyahu could present that starting on July 1st to the Knesset to begin the process of annexing all the settlements and annexing the Jordan Valley, which is proposed in the Trump peace plan. Came July 1st, nothing started. Came July 8th, nothing started. So the question was why? Many answers. One, that was merely a political ploy, a campaign to his base to say he's going to annex and then find a reason he wouldn't. Another is there was worldwide upset with the plan to annex. Europeans were threatening to impose sanctions on Israel. The American Jewish community, the reform and conservative movements, and many organizations objected to it. There was a great deal of hostility to the idea of annexation. And very importantly, Jordan, with whom Israel has a peace agreement, was very much opposed to it and said, we don't know, we won't have control. We don't know what will happen if you go ahead and annex. There may be another intifada. And so that may have been a reason. But maybe the real reason is because they were in the process of completing negotiations on an agreement with the United Arab Emirates. Because if they're going to have an agreement with United Arab Emirates, they couldn't do it at a time Israel had started an annexation process. And so we have an agreement with UAE, which next week is going to be celebrated and signed officially in Washington, which normalizes the relations between the UAR and Israel. And all of the publicity coming out of that is almost euphoric. The government people, they're very welcoming the UAE. We're very welcoming. It's mutually beneficial because trade, technology, and principally joint efforts to contain Iran. So the euphoria is not just related to the plan, but it also relates to the possibilities of now other countries who were waiting on someone to normalize relations with Israel will also do so. Realistically, practically all of them are doing business now with Israel under the table, not openly. Saudi Arabia is the key. Saudi Arabia has announced it will not enter into a normalization agreement until Israel makes a deal with the Palestinians. And Bahrain will probably join in. It doesn't have much of economic relations with Iran. Qatar is a very interesting, whether or not it will. It supports Hamas, but that's with Israel's consent. You know, sometimes you engage with your enemy against a common. Israel wants to keep Gaza from falling apart, and so it permits Qatar to assist millions of dollars to assist it from collapsing. So it's unsure whether it will do. But even those who are euphoric and say, yes, now there's been taken away from the Palestinian Authority the Arab support. And now the Palestinian Authority, for their own well-being, will come to the negotiating table. That's the pressure. That's the pressure being put on. But there are some dangers, aren't there? Maybe that isn't going to be the Palestinian reaction. Maybe they're still in the process of saying no, and we're not going to react under this kind of pressure. They're going to hold meetings already with Hamas, their enemy, which is in Gaza. Hamas threw them out of Gaza, had a military defeat of the Palestinian Authority. Hamas now is going to team up with the Palestinian Authority. Hezbollah in Lebanon. Hezbollah really controls Lebanon. It has its own military force, greatly supported by Iran. And of course, Iran is out there still supporting Hezbollah. So the other side of the euphoria is that maybe it won't push the Palestinians to the table at all. Maybe what it'll do is force them to become more radical. And what was that Israeli movie series, Fauda? You saw the difference between the Palestinian Authority and Hamas. Israel is helping both Jordan and the Palestinian Authority in controlling Hamas, and Palestinian Authority is helping Israel, protecting it from guerrilla attacks. So maybe the euphoria won't come to be, and maybe there is another side to it. So I have not been very popular with some of my friends when I throw some cold water on their optimism. The Palestinian issue has to be resolved. There's no way that Israel forever can be responsible for its security by being responsible for what's going on in the West Bank. So maybe the Arab countries, which are now making love with Israel, will put pressure on Israel, not only to be more open in terms of its relationship with the Palestinian Authority, to not insist all of its settlements be incorporated. The larger cities, yes, maybe some of the settlements. In other words, to be open to negotiations. And of course, they have to pressure the Palestinian Authority into giving up their claim to all of the West Bank, giving up their claim that the Israelis are invaders, and recognizing that Israel is a part of the Middle East. So that is something that I would not want to predict. I happen to notice my brother smiling on the camera because he's a little more optimistic than I am, and he's talked with, among others, Clinton Bailey in Israel and other people, and so he has a basis for his optimism. I acknowledge that there is a basis for optimism, but I also am concerned about the opposite reaction. And so that is now the government, what is the Israel government's position? They have said, Netanyahu has said, I've only temporarily agreed not to doing any annexation. And that's a part of the pressure to get the Palestinian to the table. UAE says not so. It's a permanent withdrawal, and Israel has to make an agreement with the Palestinians, which they will help with. So maybe this agreement will modify the position. And who is unhappy? In addition to Hezbollah, the Palestinian Authority, and Iran, who else is unhappy? The settlers, some of the settlers. Why is that? The settlers have been there. The families have grown there. They've been there 20 years. They've been there longer than 20 years, 30 years. This is their home. And they don't want to face the possibility that some agreement will be made in the future for a Palestinian state. So, a poll out yesterday, the most recent poll, the party that has gained the largest number of seats in a projected poll if an election were held today is Yamina. The Yamina party is to the right of Netanyahu. They are the ones who have proposed the annexation, pushed the annexation. They pushed other issues that Steve and Stan will speak about. Yamina is now going from 8 to 21 seats. And the poll shows that the right wing, made up of Yamina, which is now sitting in the opposition because they didn't want to sit with Netanyahu, that Yamina, the Likud, the two religious parties, will have 65 seats if the election were held today. And so the issue of annexation will be kept alive by Yamina. They are critical. And Netanyahu has lost seats to Yamina. And the other government figure, blue and white, Gantz, has lost seats, and who picked them up? The part of his party, Yesh Atid, which broke away from him because they wouldn't sit with Netanyahu. They've picked up all the seats. So the government is in a very, the two major parties are in not well thought of. The government is thought to be inept in its dealing with the virus. Right now, Israel has the highest per capita virus in the world. And they cannot seem to close down. They were going to close down the religious parties at holiday time, said no way. So now they're going to close down after the holidays. So but they go back and forth as to what they're doing. Economically, just as we are here, are hurting very much. So the question is, will Netanyahu, when he has the next opportunity to collapse the government, which is a December 23rd deadline, in the coalition agreement, it provides that if no budget is adopted, and then by, I think it was July 23rd, that elections would automatically be held. They couldn't resolve the budget issue because Netanyahu and Gantz both play around with politics, and they each felt it wasn't in their interests. So, and very tense up to the last second, kicked the can down the road to December 23rd. If they don't enter into a budget agreement on December 23rd, the government automatically collapses and a new election is in power as the interim prime minister. If it doesn't collapse and stays in existence, then next November, Gantz will become the prime minister, which very few people think will actually happen. So you have to keep your eyes open for what's going to happen on the West Bank. You got to keep your eyes what's going to happen on the government on December 23rd. And so the government has been very unstable for several years. They're operating without a budget, which creates an awful lot of problems. And The healthcare system is stretched to the extreme. Schools are stretched to the extreme. Classes are very large. What used to be the most wonderful school system has deteriorated. This is because of the absence of a budget over several years. So I think you can undo your seatbelt. I have to undo mine because I was talking faster than I'm accustomed to try to get through all of this. So unfasten your seatbelts. Think of your questions, and we'll get back to them later in the program.
Thank you, Harold. Stan.
Okay, I guess I have to talk really quickly. As earlier mentioned, one of the reasons for our trip to Israel last June was the sense that American Jewry no longer had the support of Israel in the forefront. And we wanted to find out for ourselves, what are the issues over there that we can come back and clarify over here to better understand them. I always preface this part of my remarks by saying, number one, Israel is our homeland, the homeland of our people. It's a Jewish state. Despite whatever differences we may have with its politics, we need to be supportive in any way with which we are comfortable. When we planned this trip, I suggested that as lawyers, we should meet with our counterparts in Israel, including judges and academics, but not politicians and rabbis. My responsibility here is to talk about the challenge to the High Court, the Supreme Court of Israel, and the proposed override law, which is something that we as Americans have great difficulty in understanding. I quickly learned that it's almost impossible in Israel to separate or omit the political from any discussion on any subject. By way of introduction, I believe we need to understand the Israel form of government as compared to ours here in the US. I apologize in advance to those of you who are familiar with the two different forms of government. Israel does not have a written constitution, as Harold mentioned earlier, like we do. Therefore, Israel does not have different branches of the government that can act as checks and balances for each other and for the people, such as executive branch, which is the president here, including his or her cabinet and various departments. Israel's Congress, of course, is the Knesset, which is the legislative and only branch of its government. There are no other independent branches of government to balance whatever the legislative branch does or proposes. In a few minutes, I'll explain how the courts fit into this scheme, but for now, suffice it to say, the judiciary is not a branch of the government, independent of the legislative, as much as it tries to be independent. The prime minister is not the same as our president, but rather is chosen from among the members of the Knesset based on political parties and their head count in the legislature. The 1948 Declaration of Independence, much like ours from 1776, is merely a statement of principles, such as democracy, that Israel is the birthplace of the Jewish people, mention of the Shoah and its survivors, the UN November 29, 1947 General Assembly resolution for the establishment of an independent Jewish state in Palestine. It's worth noting that no specific borders were defined in the UN resolution, nor in the Declaration of Independence. Declaration that from the termination of the British mandate at midnight of the 14th, 15th of May, 1948, until October 1, 1948, the then Israel National Council was to act as the provisional administration and provisional government pending drafting of a constitution. And I emphasize that. It includes an appeal to the UN to assist the Jewish people in building the state and to admit Israel into the family of nations. Read that as you may. It also says that, quote, in the midst of the wanton aggression, we yet call upon the Arab inhabitants of the state of Israel to return to the ways of peace and play their part in the development of the state with full and equal citizenship and due representation in its bodies and institutions, provisional or permanent, end quote. This last issue raised by the Declaration of Independence was addressed in the discussion on the recently adopted nation-state law, which Steve will talk about in a little while. I mentioned earlier, borders are not mentioned in the Declaration of Independence, except by reference a commitment to implement the UN partition plan, which also doesn't specifically state borders. Paragraph 13 of the Declaration of Independence provides the state of Israel would, quote, be based on freedom, justice, and peace, as envisaged by the prophets of Israel. It will ensure complete equality of social and political rights to all its inhabitants, irrespective of religion, race, or sex, end quote. The Declaration does not carry the same weight as a law passed by the Knesset, nor a case decided by the High Court. Our Supreme Court decides cases based on our Constitution and the court's interpretation, and often whether laws passed by Congress fall within the meaning and intent of our Constitution. Israel has no such process for the High Court to follow. Therefore, the law courts in Israel constitute a separate, independent unit within the Ministry of Justice. The judiciary acts as Israel's watchdog over the rule of law and individual rights, as do similar institutions in other countries. However, the absence of a complete written constitution, including a Bill of Rights, places the judiciary in Israel in a more important yet delicate position. The constitutional position of religious law in Israel has always been controversial and indeed inherently problematic. Israel is described in two of its basic laws, one of human dignity and freedom, and the other of freedom of vocation, as, quote, Jewish and democratic state. There are those who would challenge that phrase, which we use all the time, saying you can't have it both ways. The meaning of the phrase is a matter of great dispute. It could be taken to endorse the position of Jewish law as a source of law. However, the primary source of law in the state is statutes adopted by the Knesset, subject to basic laws, also adopted by the Knesset. There are some who would say they're inherent conflicts of interest. The Foundations of Law Act in 1980 mandates that when a court finds a legal issue cannot be resolved by reference to legislation, judicial precedent, or analogy, it will render its decision in light of principles of freedom, justice, and peace of the Jewish heritage. The loosely formed court system under the jurisdiction of the Ministry of Justice, which is headed by a member of the Knesset as a cabinet minister, makes for contrast and constant tension between the High Court and the government, namely the Knesset, the Prime Minister, and the cabinet. This can then take the form of the Knesset proposing legislation that attacks decisions of the Supreme Court.
He's reading.
That leads me to the override law, which is on the docket but not yet passed. It's being proposed by the Knesset as a new basic law, which would mean it's a law of higher standing than an ordinary statute. Basic law, which would entitle a legislative body to overrule decisions of the High Court by a simple majority, 61 votes. In our meeting with retired President of the Court, Aaron Barak, generally considered a liberal progressive jurist, whose very close friend, by the way, was Antonin Scalia, which may sound strange. He surprised us by saying that he would not be opposed to an override law, provided that the vote to override a court decision would need at least 90 Knesset votes out of 120 to do so, such as a supermajority. Our discussions also address the issue of an override law essentially negatively affecting the independence of the judiciary, a concept that we here in the US often find concerning when judges are appointed based on political rather than abstract criteria. For a true democracy, the judiciary must remain independent of the other branches of government. There are those who argue that attacks on the court are an attack on democracy. Some would question use of the word constitutionality if there is no constitution. Until 1995, 47 years after the Declaration of Independence, it was deemed that the court would not declare a law unconstitutional, even though Israel does not have a written constitution. However, in the case of United Mizrahi Bank against Migdal Cooperative Village, the Israel High Court relied actually on the US Supreme Court case of Marbury versus Madison, decided more than 200 years ago, to espouse the principle that, in fact, it has the right to interpret the constitutionality of a law passed by the Knesset. However, the Knesset in recent years has been challenging that principle, and thereby the appearance of the proposed override law. I'm sorry? Oh, some politicians would say that High Court is controversial because it has entered the political arena, such as canceling laws adopted by the Knesset, intervention in government rulings, and being activist. Some have indicated that the court has been under attack by citizens for years, and it's weak because there is no constitution. Among some of the liberals are those who advocate that Israel must have a Supreme Court in order to prevent the majority from doing whatever they want with regard to state, religion, asylum seekers, and so on. In a later discussion with retired Vice President of the court and former Attorney General of Israel, Eliakim Rubinstein, when we talked about how much an override law could not be passed in the US based on our principles of balance of powers in the three branches of government, he quipped that, quote, "You've been at it for more than 240 years. We have only 70 years of experience." End quote. As discussed by Steve, as Steve will discuss, Israel has different types of laws that are passed by the Knesset. Among them, the most important are the basic laws, of which the nation state law is one. He will address the issue of basic laws, the concept that they're intended to be the preamble to or part of a written constitution someday that may be adopted in Israel, so that the court's hands now are tied by not being able to declare such laws unconstitutional. Now, the appointment of judges, that's another issue, a case in point with the attacks on the Supreme Court. Judges are appointed by a blue ribbon panel or committee consisting of members representing the Israel Bar Association, the Knesset, several present sitting justices on the Supreme Court, and appointees from the Ministry of Justice. The object and goal is to make sure the committee is nonpartisan and non-political. As an aside, the Attorney General of Israel is chosen in the same manner. He or she is not a member of the cabinet chosen by the Prime Minister from among the members of the Knesset. The Israel Attorney General serves a 7-year term independent of any changes in the Knesset and the government while he or she is acting. It is not like here in the US where the Attorney General serves at the pleasure of and concurrent with the President. The present government has advocated changing the system of choosing justices for the High Court to one that gives the Knesset the power and authority to appoint after hearings similar to those we have in the US Senate for nominees of the President. The people with whom we met, including several law professors, deans of two of the law schools, 4 retired justices of the High Court, and others, were not adamant about Israel desperately needing a written constitution. I, for one, was a bit surprised to hear that across the board. They seem to agree on the need, but not the urgency. We Americans have difficulty understanding that concept since we have been living within the Constitution, a written Constitution, for more than 240 years. With our Supreme Court able to interpret that Constitution when looking at challenges to legislation promulgated by Congress and/or state legislatures. Likewise, we have 50 states that, with regard to certain limited matters, have some autonomy and authority subject to our federal laws. Israel has no such subdivision of government. So to conclude, I found a quote in the November 29th, 2019 editorial of the New Jersey Jewish News. Quote, Israel often and rightly defends itself as the only true democracy in the Middle East. Its commitment to free and fair elections, the civil liberties it extends to its citizens, and the smooth transfer of power that have marked its history attest that this is no idle boast. Israelis have lately begun to complain that perhaps they suffer from too much democracy. However, it is our Jewish homeland, and I urge that we support it in any way with which we're comfortable. Thank you.
Okay. Thank you, Stan. I'm going to talk about the nation-state law, because that was one of the precipitating developments, let's call it that, that led to our thinking about making this trip that we did make. Because it also, the nation-state law, when it was enacted, attracted a lot of attention here in the United States, as I mentioned earlier, mostly negative attention, because it appeared to be a gratuitous act on the part of the Knesset that had negative impact on minorities in Israel, and also embedded certain other concepts that were difficult for us to understand. So I want to talk a little bit about the nation-state law. I know we're running over time a bit, and I want to leave time for questions. So let me just say that the law, which was enacted last year, actually was intended to be, a previous version of it was intended to be, and this law was, which is a basic law, by the way, was intended to be a preamble to an Israeli written constitution. That was the original idea behind this nation-state law, that it would be a preamble, and it would set out, as a preamble to our Constitution does, as well as our Declaration of Independence, set out fundamental principles of the state with reference to Israel's Declaration of Independence. The major objections to, and we're going to put up, Alyssa, could you put up the nation-state law on the screen? So the major objection to, I don't know if you can read that.
That's okay.
Yeah. So the major objections to the nation-state law is really what's missing from the document, not what is in it. Particularly the principle or concept of equality, or a statement that equality was a fundamental principle of the state. When we met, you've heard already a couple of references to our meeting with Justice Barak. And one of the things that he said to us, because we talked about a written constitution, and Barak said, we can't and won't have a written constitution or a full constitution unless we embed equality, political equality, social equality, voting equality, equality. Until then, we don't have a real constitution, and we won't have one until we reach that objective. So, but looking at the document, what's happened with the nation-state law, and I'll go through some of the specific provisions that were troublesome. There have been 13, as of now, about 13 petitions filed against the law in the Supreme Court of Israel, the High Court of Israel, I should say, arguing that this law, even though it's a basic law, is an unconstitutional basic law because it is in conflict or in tension with the Declaration of Independence, specifically language in the Declaration of Independence about equality and a democratic state. Sorry, can't hear me? Can you hear me?
It was a little,
Am I coming through?
Yeah, I hear you.
Oh,
A little louder is good.
Yeah, talk a little louder.
All right. So let me take one section of the law as an example. All right. First of all, it says only Jewish people have a right of self-determination in Israel. So it's basically depriving other the Arab population, the Bedouin population, other population, Christian population, a right of self-determination. So that's one issue that's raised concern. And the question is, what does that mean? Another section of law, which is the clause entitled Jewish settlements, and it's that is 8, clause 8, says that, the clause is titled as Jewish settlements. It appears to privilege Jewish citizens over other ethnic groups in regard to the allocation of land for development. And we could read the provision. It says the state regards development of Jewish settlement as a national value, Jewish settlement as a national value, and shall act in order to encourage and advance its establishment and strengthen it. Now, you'll see that I won't get to the amendments that have been proposed yet, but that was a provision that created concern because it seemed to imply that the Jewish people, the Jewish citizens of Israel would be privileged over non-Jewish citizens in terms of the allocation of land and in terms of development funds and so forth, real development or money from the government to develop new communities and so forth. And also this language seems to be in conflict with a decision by the High Court of Israel in a case called the Kaden case, K-A-A-D-N, where the court, led by Justice Barak, held that a land allocation rule that barred Arabs from purchasing land in an area set aside for Jews only was unconstitutional. He used that term, unconstitutional. And he relied in that opinion on the rationale of Brown versus Board of Education, barring separate but equal as inherently unequal and unconstitutional. And they struck down the law. The government later introduced the notion of an admittance committee law, which gave settlements the authority to reject Arabs or non-Jews on the grounds of not matching the social cultural fabric of the community. There was a case challenging this law that was based on the Kaden decision that went to the Supreme Court in 2014, but it was dismissed for lack of so-called ripeness. So another clause that caused a lot of consternation among the non-Jewish population was the demotion of the status of the Arab language, which was from the very outset of the State of Israel an official language on a par with Hebrew. It reduced the status of the English language to a secondary language and a non-official language.
Arabic.
Arabic, I'm sorry. I meant the Arabic language. So the national state law and attempts to modify and or have it declared unconstitutional raise an interesting legal issue, which I want to talk about for a couple of minutes, and then I'll try to wrap up quickly. But it raises the issue of whether a basic law, which is considered a chapter, by the way, I wanted to mention this also earlier. When Israel was, the original founding of Israel, the intention was, and I think it's in the Declaration of Independence, was to have a written constitution. But that didn't happen, and it still hasn't happened for lots of reasons. But what the Knesset then passed a law that said that we will enact what are called basic laws, and each new basic law will be a chapter in a constitution, a written constitution that we will eventually enact and we will have. So this law, the nation state law, is a basic law. So it's a new chapter, if you will, in it is a forthcoming Israeli constitution. And the question is, since it's a chapter in a constitution, can it be held itself to be unconstitutional? In other words, can the High Court declare a basic law unconstitutional? That's a challenge right now to the nation state law. And this implicates the question of whether there are ultra-constitutional principles that can be invoked by a court, the High Court, to override basic laws or be applied to interpret basic laws. And this is an ongoing issue now in Israel. Now, Israel has a Declaration of Independence. And if we look at our situation or our history here in the United States, we know that in the US, that our Declaration of Independence has been used in constitutional interpretation. Professor Charles Black from Yale, who was an outstanding constitutional scholar, said that the Declaration of Independence is the one legal instrument on which all else rests. Justice Stevens, in a case involving minority employment rights, cited to all men are created equal in the Declaration of Independence. Numerous cases have relied on the pursuit of happiness language in our Declaration of Independence. So in an interpretation of a basic law, would it be appropriate, is it appropriate to look to the Israeli Declaration of Independence? In a 2011 case, the Bar-On versus Knesset case, the High Court did reference supra-constitutional principles which relate to the Jewish and democratic character of the state. So there are now, as I said, about 13 challenges to the, at least 13 challenges pending to the nation state law. The group put together by Justice Rubenstein offered or submitted to the Knesset ideas for certain amendments to the Constitution, to the nation state law, including new language about the Arabic language, that it would be considered a second official language instead of a non-official language. They would expand the language about the settlements by striking the title of that paragraph 8 to just settlements, and add a clause that all in the spirit of principles of this basic law and for the benefit of all its inhabitants, to clarify that Jewish citizens of Israel would not be privileged over others in terms of the allocation of land and financial support to develop and build settlements and so forth. And then they proposed a couple of other changes as well, including a new preamble, which I just want to read to you, or a new purpose language, which would say, the purpose of this basic law is to protect the status of Israel as the nation state of the Jewish people, in order to anchor in the basic law values, the values of the state of Israel as a Jewish and democratic state, in the spirit of the principles of the Declaration of the Establishment of the State of Israel, which includes equality. So there would be a specific reference to the Declaration of Independence, which includes an equality clause. And I go back to what, I'll wind this up by going back to what Justice Barak said to us, that until we have true equality in our Constitution, we won't have a Constitution, whether written or unwritten. So far, the Knesset has not taken up the recommended amendments to the nation state law. And the court has not taken any of these cases yet. They're pending cases. So we'll see what happens. But again, I think the nation state law, brouhaha, if you want to call it that, which got a lot of attention here in the United States, was a kind of a specific example, or was a specific example of some developments in Israel that were causing questions and consternation to be rising about what's happening in Israel here in the United States. So I'll finish up with that and we'll go to questions. We have some questions, Alyssa?
All right. Yes, thank you. I have over here, it looks like somebody asked a question and Uri Regev answered one. So first I will ask, okay.
Just to let anyone raise their hand for a question.
Well, I have some questions there.
They've already been submitted.
Yeah.
Only two of them.
It looks like we have some, I'm just reading through, it looks like we have some comments as well. So Jane had asked if Menachem Froman's efforts in Gush Emunim have any traction, and this is where Uri Regev wrote his response. I don't know if either any of you would like to further elaborate. If you want to take a look in the chat.
Why don't you read what he said?
Okay. So
Yeah,
Uri
no-
wrote, unless Uri wrote, I am afraid not. Jane, as you know, Rabbi Froman passed away in 2013, and I don't see much traction to his unique peace efforts, but as you may know, his approach was complex and unique. He, for instance, opposed the disengagement and opposed uprooting of settlements. He opposed LGBTQ and came out against the Pride Parade in Jerusalem. And I believe he maintained that a religious family should sit Shiva over a child that came out of the closet.
I want to add, if I may, a comment about something Steve said, so it's not misunderstood. The basic law of humanity and dignity does not use the word equal rights, but the Supreme Court has read into the document equal rights. And so there are equal rights under the Supreme Court interpretation. Now, the Supreme Court's interpretation, they are not plain language. They determined it on the basis of the purpose of the legislation as it determines the purpose. So it's a very broad definition, and for that reason, they have determined that equal rights are within the basic law. And the basic law has been elevated to constitutional status. And so there is, in fact, a constitution, not in writing, but not in one piece of paper. It's made up of all the basic laws, and the court has decided that is the Constitution, and those laws are then interpreted by the court. There was religious objections to the use of the word equality, and that was the initial fundamental problem with excluding it. But there are equal rights for all citizens in Israel under that human dignity basic law.
Harold, if I may, I see a question here from a friend of mine to address some of the issues behind Israel never having written a constitution. By way of my own experience, I know some years ago, our organization, the American Association of Jewish Lawyers and Jurists, was consulted, and several of our members, constitutional scholars or whatever, actually were engaged in beginning to help Israel formulate that. For some reason, which I don't know, Steve, do you know why the whole idea died on the vine?
No, I attended a 2-day program at the Israel Democracy Institute some years ago on the question of a written constitution for Israel. And it became clear that the main stumbling block to a written constitution came from the religious right, because they would not agree to any type or any sort of equality clause in a written constitution. No equal rights provision, no equality. They were adamant about it and they wouldn't agree to it. And those who were pro having a written constitution were adamant on the other side. You can't have a true constitution that fulfills the promise of the Declaration of Independence, which talks about equality, unless it includes an equality clause. And that's what Justice Barak told us that first meeting we had. He said Israel will not have a constitution, written or unwritten, until it has an equal rights.
There, Steve, we fail to agree on that because he, in his opinions, said we are now, based on the Supreme Court's power to review legislation, We have converted ourselves from a parliamentary democracy to a constitutional parliamentary
Yes,
democracy.
but Harold, he said we won't have a complete constitution. Maybe I
We
left.
won't have a written constitution, but
Right.
Not
technology is
written. He specifically said written or non-written,
well,
Right.
here,
or to disagree with you.
I must disagree with what your recall is.
I'm not going to
And it
break the
conflicts.
tie, and I was there.
It conflicts, in any event, it conflicts with his decisions, and it conflicts with,
No, it doesn't. It doesn't really conflict with his decisions, because one of the decisions that I think I mentioned involving land allocation, he specifically invoked the notion of equal rights. He quoted to our own, major case on that. And he, he specifically said there has to be equality. And that's what our Declaration of Independence demands, or not demands, but, calls for. So anyway, we don't have to quibble over that. But right now, there is no written constitution. But
Right.
the reason
And
is,
there's no active movement that I know of to go back to the drawing board to prepare one.
there hasn't been, in I think,
No,
in
it's
several years.
Yeah.
but again, I don't want to leave any viewer with a sense that there are not equal rights, because under the court determinations, there are equal rights.
Well, I think there are areas where there isn't equal rights. I think it's mostly in what I would call distributive justice, but that's another topic for
That's
another.
a different topic.
Another day. But it is a constitutional issue, though, the issue of distributive justice as well as social justice and so forth.
In this country as well.
Yes, in this country as well. So anyway, we can leave it at that. But
Okay, and we do have another question. It just came in from Iris. Apologize, I probably can't pronounce her last name properly, but the Palestinians have rejected every offer of Israel to settle the disagreement between the two groups over the demand of return of all descendants of refugees. This is what gives me little hope that we will have a change. Comment. Asking for a comment.
The hope, as I said, the hope is that now that the Arab nations have gotten out from under their commitment to the Palestinians, right or wrong, that pressure may be applied on the Palestinians, as well as pressure on Israel, to both parties have a touch more flexibility. I love letters, Yossi Klein Halevi's book, Letters to My Palestinian Neighbor, where he talks about, we both have claims to the entire territory, but we've proved we can't live with each other. Let's each keep our narrative of what our claim is. Yes, I will miss Hebron. Yes, you will miss Jaffa. But we have to, for sake of harmony and peace and cohabitability, we have to decide that we're going to cohabit, recognize each other, and retain for our own sense the belief, the narrative that we are entitled to the whole, but cut justice in half and give each a part of it. So it's only if, you can't always get what you want by pressure. You know that from daily life. You resist pressure. So I think Israel has to hold out some sort of carrot, one that it can live with, not giving up any sense of security, but hold out some carrot that fulfills some needs. There was early talk years ago when negotiations were going on 20 years ago. Okay, they demand the right of return. Let 5,000 come back. Let 10,000 come back. But they walked away. So maybe pressure and a little honey together will do something which most people, or many people, don't think is possible today or in our lifetime. Some issues are so deep.
Let me get to another question.
Go ahead.
Before we cut you off. Peter Buxbaum asked, hasn't the Supreme Court in effect held that the basic laws are the elements of a constitution? Yes. I think I said that in my presentation. I said that there's actually a Knesset law, a law enacted by the Knesset that says that each basic law, that established the concept of the basic laws, and said each basic law shall be a chapter in and ultimately what will be a written constitution. Yes, so that is the case. So the basic laws are intended to be chapters, not intended, they are held to be chapters in what will be ultimately a complete constitution, whether it be unwritten or written. So, and Uri, by the way, I have to divert for a second and give my regards to Uri Regev, who is the president of Hadush, a terrific advocate, both in Israel and here in the United States. And I'm glad to see you were on, Uri. Thank you very much.
So, Steve, by sleight of hand, you seem to be saying that Israel kind of has a written constitution, just in pieces, and you got to know where to look for it.
It has a it has a partially written constitution.
So
That's
it's got,
correct.
in effect, it's almost got the 14th Amendment in the basic law, human freedom and dignity. So
Yes, I mean, yes, and
that's something.
That's the most critical basic law, of course, in terms of individual rights, human rights, civil rights, etc.
Yeah.
Is that particular basic law. But all of the basic laws, I think there are now about 15 of them or so, or maybe 20 of them, are intended to be, or are not intended to be, they are chapters in what would be, and is to some extent, an existing constitution. Which raises the issue that I raised in my remarks about how do you find a constitutional provision unconstitutional, which is one of the claims that is being made about the nation state law. And again, I think the way you might be able to do that, or the court might be able to do it, is by interpreting the nation state law in terms of the Declaration of Independence. Just as I pointed out, there are numbers of cases, many cases here in our Supreme Court here in the United States, going all the way back to the early days in the 18th century, that invoked the Declaration of Independence as an interpretive tool in determining what the specific language of a law or a constitution, or even a constitutional provision, means. So that kind of interpretive project can be undertaken in Israel as a way of challenging some of the language of even the basic laws, and particularly the nation state law, or portions of the nation state. I'm actually writing an article about that, by the way.
I think Richard Horowitz just had a question kind of in a similar vein, and I think that might be time to close it out, but thank you so much to everyone. Well, Ron, we had one other question, but thank you so much to everyone for staying a bit longer, and I'll give you all information, follow-up information in an email, so that some people requested the slides, some people requested notes, and I'm sure Harold, Stan, and Steve would be willing.
You can send us follow-up questions, by the way, and we'll answer them or try to answer them. And also, as mentioned earlier, this has been recorded, this session, so you can go back and hear it again and listen to it again.
Yes.
I just wanted to add, this is Ron. I just posed a question that you can't answer, but it was a discussion at an Arts and a World Union meeting a long time ago, and I'd appreciate if you could answer it after the end of the session.
Sure. Is
Ron.
okay.
Thank you, everybody, for attending.
Well,
We will.
I'm just going to do one quick one from Richard. When Israelis talk about a constitution, they're really referring to rights, as in the Bill of Rights. The American Constitution, adopted in 1789, however, created a three-branch government, with the Bill of Rights amended to it in 1791. It's the three branches of government that enables the rights to be implemented. If Israel establishes its constitution, meaning a Bill of Rights document, without establishing a three-branch government? What mechanism is there to ensure that the two competing bodies, the Knesset and the judiciary, won't use the Constitution to gain a monopoly over the other?
Oh, that's a good question. Probably requires another session. I have to think about it. I mean, I don't see your point being prohibitive in terms of having a written constitution. Maybe I'm not fully understanding the question. So I'd be happy, we'd be happy to look at it and maybe get back in writing or something. Unless you want to elaborate on it, Ron. Did that come from Ron Cohn?
No, that
Yeah.
came
No.
from Richard Horowitz.
Richard Horowitz.
Oh, Richard, I apologize.
Richard. We had one.
I don't think it's an impediment myself in the way that Richard lays it out. And I apologize, Ron, for attributing. It's a good question, but I had the wrong question.
Yes. Carol Kaufman wrote, "What is the most important thing to Israelis when they go into the voting booth?" Yes.
Is that about the upcoming U.S. election, or is that about Israel?
No, the
Israel.
Israeli election.
What is the most important issue?
Always security. It's always security.
Probably, I would say security overrides everything, in my opinion. Doesn't mean others have a different particular interest. The religious parties have a particular interest.
I agree. It's always security. It comes down to
How many parties are there in Israel? 11 or 12 parties in the current Knesset. 27 parties or so actually ran. They have to get a 3% threshold. But in Israel, each interest group has its own party. So there isn't one single question, but overall, the umbrella, I have heard more from people about security being a prime interest, particularly since they've been pretty secure since the end of the Second Intifada. And they're afraid of doing something that disturbs that present stability.
Yes, I agree. All right, well, thanks to everyone for
Thank you. Thank you for everyone attending.
being with us. And we look forward to future programs like this. And again, I thank our partners, Kadush and J-Plan, very much for doing this with us. Thank you all.
Thank you. Be healthy and be safe.
Yes.
Okay. Now I'll follow up with everyone with any information you need. Take care.
Thank you. Thank you,
Bye-bye,
Alyssa.
everybody.